NACDL is the association of the nation's criminal defense bar.
So I'm going to talk about the Riley decision. So this is really the foundational case in this area. The Supreme Court in this case addressed whether the police may, without a warrant, search the content of a cell phone seized from an individual who was arrested. And the court concluded that absent special circumstances, they can seize the phone, but they need to get a warrant in order to search its context. And the case is interesting because it was really set out the Supreme Court's fullest explanation of why searching digital data may be different. So the court looked at the traditional rationales for the search incident to arrest doctrine, one of which is preserving officer safety, and the other of which is preserving evidence, and concluded that when data rather than physical objects are involved, those rationales aren't as compelling. It talked about safety, and it said that it did not believe that data posed the same safety risks as a physical device. The data doesn't pose any kind of immediate harm, and so the need to search the data is diminished. And then it also talked about the preservation of evidence and concluded that given that officers are free to seize the phone and secure the phone, there's not the same compelling rationale to search through the contents of the phone that there would otherwise be. And in addition, and in the most important part of the decision for all of our conversation going forward, the court talked about the privacy interest in data and how strong it remains. And a lot of these things now seem obvious, but for those of us who spent 15 years trying to litigate search cases before the Supreme Court said these things, you just confronted government brief after government brief that said things like, well, if you don't want your laptop searched at the border, you didn't need to bring it, right? Or I have this painful memory that Mike was actually there for arguing a laptop border search case and having the judge look at me and say, well, I never leave my courthouse with more than one page of the legal pad on which I'm currently drafting my opinion by hand because I wouldn't want to risk losing it. Why would anyone need to travel internationally with an entire laptop? That's sort of some kind of consent rationale. So anyway, it was so gratifying to see the Supreme Court finally say what I think many of us in this room would agree was common sense, but you didn't have anything to cite for it other than your own intuitions, and talk about the specific ways in which digital evidence is different. And as many of you know, it identified two primary categories of ways in which the privacy interest in data is stronger. And the first was that the data on the phone is simply quantitatively different. Phones have immense storage capacity. You can have millions of pages of text. There's often this analogy. Judges like libraries, right? Because they're always the quintessential protected space of, you could have the contents of an entire library on your phone. They talk about the storage of many different types of data, and the fact that, unlike taking someone's day planner, unless I guess you're Judge Kavanaugh, the contents of the day planner are just one type of data. Whereas a phone has, your calendar and all of these other types of data that are more powerful when cross-referenced together. And in a really, maybe a sign of things to come, the Supreme Court also talked about the capacity of phones to contain historical data, including location data going back for a long time. And suggesting that created an added privacy interest, something Nate, who's with us here today, may have capitalized on when he litigated the Carpenter case in the Supreme Court a few years later. And then the Supreme Court also talked about how the data on phones was qualitatively different. It recognized things like the sensitivity of your entire browsing history, how app selection can indicate things about your political beliefs, can contain health information, and so on. And based on the diminished interest in safety and evidence preservation, but the strong privacy interest, the court said that in the normal course, law enforcement agents can't rely on the search incident to arrest exception to engage in a warrantless search of an electronic device, a phone, taken from an arrestee. There were some nods to special cases, which have come up in the aftermath. The court confronted two government arguments about circumstances in which they might actually have a strong need to preserve evidence. It floated the possibility that someone would remotely wipe the data, and also the possibility that the phone would become encrypted in a way that would prohibit the government from accessing the data later on. Based on the record that the court had been presented, though, the court dismissed those claims as quite speculative, both in terms of saying you've given us very few examples of when this has actually been a problem for you, and in terms of suggesting that the ability to conduct an immediate search wouldn't actually help alleviate the harm that the government had identified. Yeah, I think many of us have wondered that in the aftermath of this case, whether the increasingly strong encryption on phones might potentially change the calculus. The Supreme Court did, of course, leave law enforcement out. It cited the exigent circumstances exception to say that although the normal rule was that you have to get a warrant if you did believe that evidence would be destroyed absent an immediate search, you could still rely on that exception. And so it may be that as it becomes harder to unlock a locked phone, that exception may grow and even potentially swallow the rule, but that's something we'll still have to wait to see. And I think the other big question coming out of Riley is how it applies to other devices that weren't an issue in that case. So flip phones are one question that people raise: how does this apply to flip phones? One of the phones in Riley was actually a flip phone, and the court just dealt with all phones in the aggregate. And so district courts in the wake of Riley have concluded the government needs a warrant to access those also. There's also been district court case law saying that the rule of Riley applies to searches of digital cameras and of thumb drives. And so I think the key point that the court recognized is that phones, as we all know, are merging with all sorts of other electronic devices, and so it conceived of the case as not just being a case about a phone, but a case about digital storage media generally. And I think based on that, there are all sorts of potentially profitable arguments to be made about warrant requirements for these devices. I don't know, Mike and Esha, if you have anything to add. Otherwise, we can talk about the border search exception.
No, I think it's an interesting question to see how far Riley can extend, and the cases that we're seeing now tend to sort of skew towards the outer varieties of devices that are around there. One of the ones that we just dealt with was an 8-gigabyte flash drive, and the court said, yep, Riley applies. So I think anytime you're dealing with any sort of device that is more sophisticated than a 2007 flip phone, which is what it was in Riley, or you're dealing with something with the capacity to hold that much, then Riley seems appropriate.
Yeah, and I would also add that even if you're in a context where potentially a court might be sympathetic to a government argument that the privacy interests are reduced because the content is somehow qualitatively different than a smartphone, I still think Riley's discussion of the government interests is relevant in terms of, digital is different, right? You're not going to have the concern about concealing weapons or destruction of evidence that exists with physical goods. And so I think it's important to resist trying to erode Riley in that way.
So do you want to take us on a tour of the border search case law? Yeah. And I have to say, you've been personally involved in litigating all of the most exciting cases in this area. I'm quite jealous.
Yes, we miss having Catherine at the ACLU, but I have been involved in litigating a lot of the post-Riley cases addressing border search doctrine, which I will talk about. And I think post-Riley is really critical here because the Riley decision has in some ways changed the game. At the moment, I am, along with Nate Wessler, who's here, counsel for 11 plaintiffs who are challenging the government's warrantless device search policy at the border in a case known as Al-Assad v. Nielsen. That's in the District of Massachusetts, and that's an affirmative case, and we're co-counseling with the Electronic Frontier Foundation and the ACLU of Massachusetts on that. But many of the cases I'm going to talk about, especially the cases that have already gone up to the circuit courts, have arisen in a criminal defense posture. So I think it's really important sort of to keep an eye on how the doctrine is developing, particularly because a lot of it is developing through criminal appeals. So I can go to the next one. Yes, thanks. Just to give a very quick overview of what the government's border device search policy is. Right now, the government takes the position that it can search electronic devices at the U.S. border without a warrant or any suspicion. This means if you're a traveler coming into the U.S. at a port of entry, land or airport or seaport, you can be searched. But it also applies to exit searches, and we have had cases come up where individuals are at a domestic airport boarding a flight to go overseas, and they've been searched by Customs and Border Protection or CBP agents, warrantless searches. And so this is something to keep in mind, that the government's interpretation of its authority is broad. The relevant directives are a Customs and Border Protection 2018 directive on border search of electronic devices. And this directive was issued in January 2018, and it replaced a previous directive of 2009. And I'll just give some brief discussion of salient points from the directive, but I encourage you all to read it in detail if you do end up with a case involving a border search. The CBP directive makes a distinction between what it calls advanced or basic searches. Advanced searches are defined as any search in which an external piece of equipment is connected to the electronic device to be searched. So leaving aside, for purposes of battery connection, right? If the phone died and they plug it in just to get the battery, that wouldn't be an advanced search. But if they used any external equipment, like a Celebrite device, to search that device, that would be defined as an advanced search in the CBP directive. All other searches are basic. That would be, an agent flipping through a phone, maybe using the internal search function. And CBP uses this terminology, even though most of the case law has used the terminology of forensic versus manual search. It's unclear why, but I think nonetheless, their definition of advanced would certainly encompass everything that the courts have considered to be a forensic search. The CBP directive imposes a reasonable suspicion requirement for advanced searches, which is positive. It is an improvement from the previous 2009 directive. Basic searches can be done without suspicion whatsoever, no reasonable suspicion requirement. However, even for so-called advanced or forensic searches, there is a workaround to the reasonable suspicion requirement, which is whenever the government thinks it has a national security concern. And among national security concern are things such as being placed on a watch list, which is itself, a designation that is very hard for an individual to challenge. So the national security concern workaround is troubling, and I don't think we have enough examples from cases that have arisen to see how CBP interprets that and how broadly they apply it to get around a reasonable suspicion requirement. And in part, I think this is because, unfortunately, courts have been, very forgiving in finding reasonable suspicion. So I will talk about that a little bit later, but essentially, a lot of sort of innocent factors at the border that we would all think couldn't amount to suspicion. I think courts have been eager to say, well, that was reasonable suspicion, so it at least satisfies the reasonable suspicion requirement and gives the government the benefit of that argument. A few other critical points from the CBP policy. It allows for confiscations of devices at the border. And it sort of lays out a timeline for which individuals are supposed to get their devices back. But from our own experience, litigating these cases, hearing from people who have clients who've had devices seized, CBP doesn't necessarily stick to the timelines, the number of days laid out in its policy. So it's not unheard of for people to have their devices confiscated at the border and kept from them for weeks or months while CBP either keeps it or they do forensic analysis on it. So this is unfortunately in the policy. And it's particularly, I think, relevant when you think about tips for traveling with your devices at the border. Because one common scenario is that someone, let's say, is at an airport and CBP asks to search their devices, and most likely they have a password on it. Agents will usually ask the traveler to provide the password or unlock the device. And for people who refuse, the risk is that CBP will then seize their devices and confiscate that and keep them beyond the time that you are at the border. So you'll be sent on your way, but you'll no longer have access to your laptop or your smartphone, which can be obviously a problem. And, again, it speaks to the coercive nature of what's going on at the border, because if you are a U.S. citizen or a lawful permanent resident, the government can't keep you out of the country for refusing to unlock your phone. They don't have no basis for not letting you enter the country. And so what can happen is people who stand on their rights and say that they don't want to unlock their devices are allowed to be admitted because there's no immigration-related reason to keep them out. But they're told that their devices will be taken. And so then some people faced with that choice will, in fact, provide a password or unlock the device in the hope that, well, let's get the search over with here so I can have my laptop and go on my way. And I think one thing to be concerned and to watch out for there is if the government argues consent. If you're later trying to challenge that search, the government will often say, well, we asked for the phone and we asked for the password and the traveler gave it. So we, in the Al-Assad case and others, have really tried to establish the factual basis for coercion in those circumstances to make it clear that they were given this sort of choice that isn't a choice at all, right? Lose your devices for untold days or weeks, or unlock your phone. The CBP directive also makes clear that CBP is not supposed to be searching cloud data when it conducts these suspicionless or warrantless searches at the border. This is, again, an improvement from the previous policy. It's very important. I think, the technologists in the room can talk more concretely about how it may often be difficult to define what is cloud data and what is not, particularly if you have an email app or a social media app that caches data on your phone. The average traveler may think, oh, all of my apps are off limits. CBP can't search that. They can only search, say, the photos that are physically on my phone. That may not be true, because even if you put your phone in airplane mode, your apps may have still cached certain data. So it's not safe to say that my WhatsApp application wouldn't show anything to a CBP officer while it's in airplane mode. So again, that's just something to keep in mind. Now, ICE also has a directive. It's the 2009 directive titled Border Searches of Electronic Devices. It allows for similarly warrantless and suspicionless searches of devices. It does not have this advanced versus basic distinction, and it does not prohibit cloud-based searches. And what we do see quite regularly is that CBP will do the searches at the border. CBP are the agents who are stationed at an airport or a land port of entry. But if they confiscate the device, they will often send it to ICE or Homeland Security investigations to do the later searches, whether that involves trying to break the passcode that a traveler refused to unlock, possibly doing a forensic analysis of the phone using sophisticated equipment that will often be done by Homeland Security investigations and be subject to the ICE directive. And so again, we have a lot of questions about whether ICE would respect the CBP limits on not searching cloud data and on only conducting advanced searches with reasonable suspicion. So these are the policies, and the number of device searches at the border has been increasing. I'll just throw out a couple of numbers. In fiscal year 2015, it was approximately 8,500. In fiscal year 2017, over 30,000 device searches. And I think, an obvious question is why? And another obvious question is, well, are these searches really only being done for border purposes, right? Is it, sort of the kinds of things that we traditionally think of as customs and immigration matters? Because what is to stop local or domestic law enforcement from simply, outsourcing its desired searches to border agents? The answer, unfortunately, is nothing right now. And so I think that, while the cases that have been bubbling up through the courts, which I will talk about shortly, some of them involve what we might think of as traditional border concerns. A lot of them involve stopping or searching for child pornography. Some of them involve drug trafficking. Some of them involve arms export or arms import. Nonetheless, I think we've also seen some cases arise where it's clear that you had a domestic investigation going on, just a traditional criminal investigation, and where the government agents did not have probable cause to get a warrant, they may and have and can ask border agents the next time that the person that they are interested in crosses a border to search their devices, because there's no warrant requirement. There's not even a reasonable suspicion requirement for an on-the-spot basic search. So we, at the ACLU and EFF and other groups have been really trying to highlight this in the cases that we litigate, which is it's not just that this is a very, very broad expansion of traditional border search authority to search your luggage to now include digital devices. It's that you don't even have to be interested in a border-related matter. You could do these searches and essentially treat the border as a loophole or as a dragnet investigative tool for whatever domestic law enforcement concerns you have. So what is the state of the law? Riley was obviously a hugely helpful case, but the government has continued to maintain that Riley was simply about search of cell phones incident to arrest. And that Riley's language, that the general rule for searching cell phones, unless an exception applies, is to get a warrant. And so we've had appellate courts take a variety of approaches. I think probably a lot of you will be familiar with the Cotterman decision out of the Ninth Circuit, which actually predated Riley. It was from 2013. And in that case, the Ninth Circuit said, you need to have at least reasonable suspicion for the forensic search that took place there, which was quite an extensive forensic search. The court found that essentially it had been a computer strip search, the laptop, the entirety of the information, metadata, all of that on there was searched. And so in 2013, pre-Riley, the Ninth Circuit said, for this type of search, this forensic search, you need at least reasonable suspicion. Now, post-Riley, we've had the Fourth Circuit in United States v. Counsel also join in with that, where Counsel was a case involving arms export. And the court, again, it was dealing with a forensic search involved there and said, there has to be some level of individualized suspicion. It didn't actually decide the matter. It left open whether a warrant might be required. So I think that actually the Fourth Circuit isn't such a limited opinion. It leaves open the possibility that a warrant might be required, but said that at least individualized suspicion has to be in place. Then we've had the Fifth Circuit in 2018 decide the Molina-Isidoro case, and it did something that I think is very typical in these cases, where it declined to decide the standard that applies for searches because it applied the good faith doctrine. And I think that that's unfortunately a disappointing development for obviously all of us in this room for many reasons. But I think a lot of courts have been really struggling with this question of how does Riley apply to the border search exception? Where traditional border searches don't require a warrant. Does that mean that cell phones are different or the same? That is a tough question. So let's instead say that the border agents reasonably relied on the long-standing border search exception to the Fourth Amendment, will apply good faith and punt the merits issue. So that's what happened in Molina-Isidoro, but we did get a specially concurring opinion from Judge Costa really laying out why, a warrant requirement has to be seriously grappled with at the border, because the traditional rationale for searching luggage, again, doesn't really apply to digital devices because, contraband can't be hidden in your phone. You can't hide the drugs. You can't hide the guns in your phone. At most, you can get evidence of the drugs and the guns in the phone, but that's evidence, and evidence has always been treated differently than the thing itself. The government, of course, continues to maintain that there is a category of digital contraband, things like child pornography or classified information. And so I think the battle for courts here is to grapple with the government interest in this category of digital contraband and whether or not it's a serious or big or large enough interest to outweigh the privacy interests in the contents of devices. And then lastly, the 11th Circuit in Vergara has held that you don't need heightened suspicion for device searches at the border. Now, again, there have been a couple of decisions out of the 11th Circuit that have at various times tried to parse whether they have to actually decide if reasonable suspicion is required or not, because they've said essentially, well, even if reasonable suspicion is required, reasonable suspicion existed here, and again, they do this very favorable to the government analysis of reasonable suspicion, right? The person showed up, they were sweaty at the border, they were a little evasive, just like everyone might be after a long flight, right? But these are the kinds of factors, innocent in themselves, that they're happy to sort of put together and say, this was reasonable suspicion. So we don't really have to be troubled with the larger, bigger question of truly suspicionless searches. And I think, again, this leaves open the question of so-called basic searches, because most of these appellate decisions have had to really just grapple with the forensic search, which I think they're all comfortable in saying, these really go beyond the average search at the border. But I think basic searches, we've always argued, can be just as invasive as forensic searches. And so taking the rationale of Riley, which was concerned with manual searches of cell phones, we've been trying to argue that there shouldn't be that distinction. And I'll just wrap up very quickly. I think we can maybe talk about tips for travelers later, but as you're seeing these cases, or if you do have a case where you are faced with a challenge to a search of a client's device that happened at the border, just have a couple of suggestions, one of which would be, to the extent that you are able to cross-examine the agents who either selected your client or the traveler or did the search. Some things that might be helpful to establish would be, one, this wasn't really a border search at all. It was intended to be a domestic investigation, and you just outsourced the search to the border where you knew you wouldn't need a warrant, right? I think those are the kinds of facts that might give a district court judge pause when it's very clear that this was not falling in the traditional rationale for border searches. No one was looking for customs violations. No one was concerned with immigration issues. It was a purely domestic investigation, and they saw an opportunity when the person was traveling. And then the other, facts that might be useful to establish are, why was the person selected for search? Because oftentimes it will be things like you are a single male between the ages of 18 and 60, which is a good chunk of adult men. And, if you can even get more, if you can even establish that maybe the reasons for search were impermissible, maybe touching on sort of things that would give a judge pause on First Amendment grounds, right? Oh, is this person a journalist? Is this person a lawyer with clients that the government doesn't love? Was this person selected, for on the basis of race or religion? It might be a good way to chip into this instinct of judges to sort of apply the good faith doctrine. And that might be an avenue to get a court to actually say, well, I'm uncomfortable with this application of warrantless and suspicionless searches.
Thank you. That was totally fascinating. Do you mind if I just ask a couple of questions and make an observation? So, the thought I'm sure we're all having is there's just so much gamesmanship in this, right? So first, there's a distinction between basic searches and advanced searches, which in some ways can be gamed because presumably if you don't want to trigger an advanced search, you could just do a manual search for longer periods of time. Then there's this issue of ICE versus CBP, right? You just shuffle around who does the search, and then the gamesmanship of the border search actually being used to further domestic investigations. And so that's just, it just seems like, it's not an uncommon story in this area of law, but it just seems like the unifying theme of a lot of this, which makes you wonder how much we get out of the CBP policy. And then I just had a couple of questions, which maybe you could touch on quickly. And the first was just, what are the demographics of the people who tend to be searched? When I sat at the ACLU and fielded these phone calls, there were just two groups. Right? There were men between 40 to 60 who were coming back from Thailand, right, or wherever, and clearly suspected of child pornography. And then there were an incredible number of Palestinian rights activists. And I just wonder if, and so that's you don't actually know what the government search criteria, are, right, what the policies underlying this are. And so, I guess I'm just wondering what your instincts are about who the demographics are that are really, where this likely to come up. And then I just wonder whether, this just may be an example where we'll spend a bunch of time in the courts trying to solve this, and there ought to be a good legal solution, but maybe technology will just outpace it, right? So I don't feel the same personal imperative to bring my laptop across the border that I used to, or if I do, I can encrypt it. Sometimes if I'm going to China, I don't actually want to bring all of my stuff anyway. For a couple $100, you can buy a use once and throw away device, right, which isn't ideal. $200 isn't nothing, but maybe it's better than taking all of your attorney-client privileged files with you across the border. So I just wonder if you have any reactions to those two thoughts.
Yeah, I think in terms of who's being searched, it's probably the same as what you were experiencing. I think it's a lot of sort of child pornography sort of operations at the border, which will say, you know, on this day at O'Hare Airport, every single man, meaning man traveling alone, between the ages of 18 and 60 coming from Southeast Asia, we will apply some random formula and some percentage of them will get searched. And then, of course, the cases that arise through the courts are those in which a search actually, you know, revealed what the government says is child pornography, and, you know, the cases all sort of, I think that the judges often have this hindsight bias, right? Well, child pornography was discovered. Of course, the factors that were used to select are at least reasonable suspicion. And then I think we do have an instinct, of course, that Muslim Americans are being searched, people of color are being searched more. You know, we have heard stories of journalists being searched as well, and you know, the best that we can maybe tell is that the government is interested in some potential sources or people that the journalist has communicated with who might be of interest. So I think that does tend to be continues to be the number of people who are searched, although notably the government releases very little information about this, and of the 30,000 searches last year, we don't know nationality, basic facts about who they were. And then, you know, as to the question of will technology solve this problem, I'm not sure. Because I think that what will happen is the sophisticated travelers will take self-help steps. You'll have attorneys who will, you know, keep things in the cloud when they travel and travel with a burner phone, or make sure that they don't have anything physically resident on the device, and you know, use sophisticated methods of moving data from the cloud back and forth across the border. I think it will be the travelers who are just less savvy, who will, you know, have their smartphones on them and will need to travel, you know, for safety reasons, for practical reasons. And, you know, and so I think that we should be concerned, right, when that's the reality that's going to exist. And if courts would be comfortable with this world in which, you know, doing something perfectly innocent and in fact probably advisable, which is traveling internationally with a smartphone, sort of leaves you at the mercy of government agents if you don't happen to be a sophisticated lawyer, journalist, whatever.
I was going to say, if you happen to be an unsophisticated lawyer and you haven't encrypted your device and used the cloud, and you happen to find yourself stopped at the border, there is a special policy that exists for attorneys coming through the border with privileged information on their devices. At least for CBP's purposes, they are you are supposed to announce that you have privileged information on your device, at which point they are supposed to go to their general counsel and work out a privilege review process with the U.S. Attorney's Office. So if you do find yourself in that position, you do not have to throw up your hands. There is some recourse for defense attorneys, at least coming through. Query whether the same sort of policy exists for, say, journalists. But I did have a question for you, Esha, which is, you keep on talking about the border. What's the border? And have you heard of anyone being stopped in that border zone?
Well, okay, so I think your question is probably referring to this 100-mile zone that we've heard about, which I'm sure many of you deal with, where the, you know, CBP asserts search power within 100 miles of any border, which is a good chunk of the United States. These device searches, I want to be clear, we have only heard of them, and the policies on their face only apply when you're actually at port of entry. So airport, secondary inspection, land crossing at Mexico or Canada, we have not heard of warrantless searches happening within the 100-mile zone. And if that were to happen, we would want to know about it immediately. I think that would be an unprecedented expansion of the policy. And just to build on what you said, Mike, with respect to the part of the policy that deals with attorney-client privilege material, yes, I think it's very important to hold CBP to that policy. So if you're an attorney and you're about to have your device searched, you should make it very clear and invoke, you know, your own policies say you have to do this. Obviously, it's hard to enforce that if they choose to ignore it, but you should at least put them to the test on that. It should also apply to your clients. And I think that that's something that, you know, if you have clients who travel a lot, right, while proceedings are pending, you should tell them, you know, arm them with the language of the policy. Maybe they should even travel with it if they're concerned about being searched. And they should, you know, be able to say, I have communications on this phone with my lawyer during a pending proceeding, so you cannot search this without violating the attorney-client privilege, and it should trigger the policies. And, you know, again, I think anything you can do to sort of empower clients with this information, it's no guarantee they won't get searched, but it at least maybe will cause a government agent to pause and go to a supervisor.
Thank you. That was totally fascinating. So, Mike, do you want to take us in a new direction?
Sure. Can I get the clicker for a second? So I guess we'll talk a little bit more about, or a little bit more in detail about accessing locked and encrypted devices. I like this topic. This is fun. So the issue here is the Fifth Amendment. We've been talking a lot about the Fourth Amendment. And the question is whether forcing somebody to decrypt their device triggers the Fifth Amendment privilege, or whether forcing them to decrypt it violates their right against self-incrimination. And the sort of key to remember in answering these questions is whether the government is compelling somebody to divulge the contents of their mind in a way that is testimonial. You'll hear testimonial is the key word here. So how does that apply when you're talking about, say, Touch ID or Face ID on an iPhone? And at least right now, the answer is it doesn't really that well. If you have a fingerprint sensor as your unlock mechanism, or you have your face as your unlock mechanism, a lot of courts that have ruled on this almost unanimously have said that forcing somebody to provide their fingerprint or their face is not testimonial. You are not requiring them to divulge the contents of their mind. It is more like taking somebody's fingerprint when you're booking them, or taking a mugshot or a hair sample or blood sample. So the law on that front is not great. That said, there is always a question of whether the government had probable cause to take somebody's fingerprint or take their mugshot in the first place. So if the idea is to just go around and press a phone up against everyone's thumb in the room, you've got a probable cause problem there. But if you are not dealing with a fingerprint sensor or Face ID, if you're using a normal passcode, then the analysis gets a little bit more interesting. And there isn't a ton of law on this so far, but there's a really fantastic case out of the 11th Circuit from 2012 in re grand jury subpoena, which talks about the passcode as being potentially testimonial. And the idea is that what's the testimony? What is the information being conveyed? Well, it's an implicit acknowledgement that you know what's on that phone, that you had access to it, that you have control and possession over it. So there's a lot that you can infer from the act of forcing somebody to successfully type in the password to their phone. And the 11th Circuit said, of course, you're forcing somebody to use the contents of their mind in a way that is potentially testimonial. And this is where we start to get into a little bit of a circuit split. The 11th Circuit looks at this like saying, requiring somebody to provide the combination to a safe is the same as requiring them to put in a passcode. It's potentially testimonial unless it is a foregone conclusion. And this is where things sort of run off the rails a little bit, and there's something of a circuit split emerging. So in the 11th Circuit, the idea is that you can still force somebody to type in their passcode if it is a foregone conclusion that they had access to that device and control over it and possession of the files on it. And that's actually a pretty high bar to clear. The test for the 11th Circuit is that the government must know with reasonable particularity that the files are on the computer, that the suspect had access to them. So the questions to ask in this case are, does the government actually know that the files exist? Does it know that they are located on that device? Does it know that the person they're trying to have decrypted had access to all that information? And it can be a pretty high bar to clear. The Third Circuit applied this test and sort of came out the other way. And it's a really good example of how it operates, because it was a passcode on a computer. The Third Circuit said, we're following the 11th Circuit. It sounds like it's potentially testimonial, but in this case, it was child pornography. The wife had seen the husband type in the password on the computer, had seen him pull up the incriminating photos in the past, and therefore the Third Circuit, applying the 11th Circuit's test, found that it was a foregone conclusion that he had access to those files on the computer. There's a similar case dealing with a Customs and Border Patrol stop, actually, where the defendant opened up his computer on request. It was a consent search. He actually navigated right to the child porn, at which point the CBP officer said, okay, I'm going to get a warrant. We're going to take your laptop. And he closed the top of the laptop. And when we went to go open it back up again, it was locked. And in that case, again, the court said, well, it's a foregone conclusion. We already know all of the information that we would have gotten out of that testimonial act of forcing somebody to type in their passcode. So you can see how that 11th Circuit test works, and it is pretty fact-intensive. The Northern District of California has taken a decidedly different approach to the foregone conclusion doctrine. It just moved the goalposts entirely. So rather than having to show that somebody knew that the files were on the computer and they had access to it and they had control over them, the test the Northern District of California came up with in a case called Spencer was, does the defendant know the passcode to his phone? Considerably lower bar to clear. And they said, well, if you can show that he knows the password to his phone, then it's a foregone conclusion and decryption can be required. So moving forward, like I said, there's not much case law on this. That is really all of it that's out there right now. But moving forward on this, you definitely want to be in the 11th Circuit bucket rather than the Northern District of California bucket. And the last thing I'll leave you with on this point is that the technology at play here is actually really important. The arms race that is sort of going on between the phone makers and the government and the companies that are trying to break into them. And the Celebrate is one of the major companies that provides those sort of services these days. There's another one called Grayshift, which makes a device that is theoretically capable, at least they say it is, of unlocking any phone that is on the market today. And that includes the most recent version of iPhones. And right after they made that announcement, Apple came out with a big news flash saying they were going to shut down the mechanism that Celebrate or the Grayshift was using. It was going to shut down the USB port after an hour so that the devices wouldn't work to break the phones. And Grayshift came out like within 24 hours and said, we already thought of that. We future-proofed our encryption breaking machine, and sorry, Apple, you'll have to try again. I don't know if that's true. A lot of it seems to be marketing, but from a defense perspective, I think it is important to point out that currently the government probably can break into any phone that they get their hands on. So forcing somebody to decrypt their phone is in many ways unnecessary and should not be required if the government has that technology available to them. So keeping up with that can be an important way of making the entire issue disappear. To just say, look, it is not necessary and appropriate to effectuate this warrant, to require anyone to unlock this phone. The government has the capability on its own. So I think that's the state of play at the moment. I'm happy to take questions on that before we move on. All right. So assuming they can get into the phone, this is where the fun part starts. Assuming that the government can get into the phone, there are a whole bunch of questions about how broad the scope of the search can be and how much of the data the government is allowed to take, assuming, of course, they had a warrant. The first question to ask yourself when dealing with one of these cases is about the connection between the phone and the defendant in the first place. So before you even get into the scope of what can be searched or seized, there needs to be a nexus between the device being searched and the person whose phone it is and the crime being investigated. It is probable cause to arrest somebody is not probable cause to search their phone. Those are two separate questions. There's a really good opinion from the DC Circuit from last year on this point. It's called US v. Griffith. And the idea here is that the government must satisfy a threshold that the defendant owned or used or possessed the actual device sought, that it might be the evidence or the device might be found in a particular place. I mean, this should all be familiar from warrant requirements, and that the device itself would contain incriminating evidence. It is not enough to just speculate that it probably does, because cell phones have a lot of stuff on them. We see this argument all the time. They say, well, the defendant was involved in criminal activity. People use phones for their activities. Therefore, the phone contains evidence of criminal activity. And that tautology does not work, or it should not work. At least that's what the DC Circuit found recently. So there needs to be a nexus between that device and the crime being investigated. If that is not there, then you have a way to challenge the search at the very beginning. Assuming that there is some sort of nexus between the device and the crime, the question starts to become one of particularity or overbreadth. Particularity is a requirement from the Fourth Amendment, that the places to be searched and things to be seized are particularly described. And overbreadth is sort of the flip side of that. If you're lacking probable cause to search all the things that you want to search, it is said to be overbroad. The 2 points are often conflated in legal opinions. The flip sides of the same coin. The general rule is that probable cause is what makes particularity possible. So if you don't have much probable cause in your case, chances are your warrant is not very particular, and you're going to be arguing that it is both lacking particularity and overbroad. There is a great example of this coming out of the Southern District of New York from last year in a case called United States v. Way. And that was actually a prosecution involving a hedge fund manager in New York and his office. The government got a warrant to search both the hedge fund office and the private residence of the Ways, the guy that ran the hedge fund. And what they did was create a warrant that allowed them to seize documents or files that related to any one of 200 or so names and entities. And one of those names was New York Global Group, the name of the hedge fund. One of the other names was Michael Way, the guy that ran it and whose apartment it was. So you can imagine what happened when the FBI went to go and execute that warrant. They raided the hedge fund office. They carted away pretty much every computer and file they could find, because most of them said New York Global Group on it somewhere. And when they raided the Ways apartment, they carted away every single electronic device, in addition to family photos, children's x-rays, testing scores, tutoring records, all of which the government defended tooth and nail as evidence of way of life in a tax fraud case. And the Judge Allison Nathan, really had enough of that and said, look, what you did was created an incredibly broad circular warrant that is totally devoid of the requisite particularity, and it's overbroad. She said it is a general warrant in function, if not in form. And the end result of that is not only suppression, but no good faith, right? If you have a warrant that is overbroad on its face or lacking particularity on its face, the rule is that good faith is not supposed to apply. So bringing this sort of challenge can be really beneficial. The suppression order in the Way case led to dismissal of all of those charges. It was a big black eye for the Southern District in what was supposed to be a really high-profile white-collar prosecution. And the lesson here is that warrants need to be particularized, right? They cannot be overbroad. And the government often comes back and they say, but that's not possible for us, right? There's a lot of stuff on computers. There's a lot of data. We don't know where things are. They could be hidden somewhere. They could be deleted. They could be booby-trapped. And we see this argument all the time. In fact, I'm putting this one quote up here because I see it so frequently that I need to talk about it. Literally every case that talks about the burdens that prosecutors face in reviewing data, cites to Hill, cites to this case from, it's actually a district court case with Judge Kaczynski sitting by designation. And he says, look, criminals are going to do everything they can, including hiding their files, changing the file extensions. And there's nothing that comes after that quote, by the way. There's no evidence to support any of that, or research or other cases. This seems to be coming out of personal experience. And maybe, in retrospect, it seems possible. And every one of these cases that cites this point, cites to the pin site back to Hill. So I want to try and problematize this a little bit. I want to talk about what actually happens. The Department of Justice runs a sort of two-step program to do these searches. Can we get it to stay on the one slide? The first step is imaging. They take all of the data off of the drive and they throw it into a forensic analysis program for purposes of later analysis. They go through it. And you can see the device, one of them here, that's a Celebrate. It's a handheld model. You can see all the connectors that comes with it, and you can see what it sort of looks like when the data is put in a raw way. The blocks that are colored have data on them. The ones that are not are unallocated. And it pulls every bit of data off of the device, and it puts it into an output format that kind of looks like this. This is an extraction summary for defense lawyers. It is, I think, really helpful to look at this. You can see who did the examination, when they did it, and what kind of examination was done. Did they pull the data off file by file using the operating system, or did they do a physical extraction of every bit of data on that device? And you can see all the information from there. But what I really want to point out here is what's going on the left-hand side in the red in particular. Everyone see the red parentheses next to the different file types. So it's pulling all the data off of this particular phone. And you can see the number of files of each type in white next to the file type. And then there's a little red parentheses next to that. Those are the number of deleted files that have been found of that type. So much for deleted files. It is actually carving the unallocated space on the device to pick up different bits and pieces of other files that may have been deleted. And then it is searching for file types by their headers, by the key signatures that are associated with them. It is not searching based on what somebody named their file or even what extension somebody gave to that file. It is looking at the data intrinsic to that file, figuring out what kind of file it is, and then bringing it into the forensic software here. So if you're going and you're looking for, say in this case, evidence of ATM theft, you can go to images and you can find images relatively easily without having to sort through somebody's personal filing system. The problem with doing that is that you can often see other things that are outside the scope of what you're looking for. And this is the plain view problem. So let's say you're going and you're looking for that ATM evidence, but you find evidence of gun possession instead. The problem is that once you have the authority to seize all that data on the phone, everything sort of comes into plain view. And this is really what happened in the CDT case in the Ninth Circuit from a few years back. And one of the major recommendations for going forward was that the government use search protocols. It didn't require them. But this software is entirely capable of sorting by timeline. So there's a timeline view. You can narrow the window of data that you're looking for and report only that stuff out. You can look at lists of contacts only, if that is the subject of the investigation, or locations that the device has been in. So this is a list of, the device itself keeps a list of all the places that it's been. You can pull that up. And there is also a keyword search function. So if you are going through and looking for particular information, you can find it by keyword as well. The important point to sort of take away from all this is that it is possible, and judges started requiring the government to particularize their warrants, especially after the Riley decision. You had this flood of cases. It was called the Magistrates' Revolt, and there were newspaper headlines all around about it, about judges in Washington and New York and Kansas declining to issue warrants, making the government come back 4 and 5 times with revised warrants, and you can sort of see what this looks like. This is actually from a case that's pending before the Second Circuit now. This is Judge Orenstein in United States v. Duran. You can see he's just crossing out the stock language and narrowing it by hand. He's putting in a date requirement and crossing out the extraneous information. So this is the sort of stuff that you should be making the government do, challenging them if they don't do. And it is entirely feasible from a technological point of view to do it. One last thing before I stop and turn it back over to Catherine. If you ever get one of these cases, make sure they give you the data in the form that they are using it. It's a UFDR report rather than 60,000 pages of PDFs. So if you end up with one of those, I have a motion you can file to get.
Thanks. We've all ended up with those PDFs, so that's very useful. So I think we need to leave it there. Thank you very much. That was completely fascinating. We could have talked about any one of these topics for a whole panel or half a day, and we'll all be around, I think, for the rest of the day. So please come catch us if you have questions. I'm sorry we ran out of time for that, so thank you.